Hi, folks. Welcome. You made it. It's the last session of the last day. Good job, everyone. Hopefully, everyone's still awake. I got some coffee. Got a little walk outside. It's really nice out there. So welcome to the Understanding DoB session. We're going to go through a lot of stuff today, a lot of new information. So that's exciting. But let's first go to introductions. My name is Jen Carpenter. I am the director of the policy division in the Office of Disaster Recovery at HUD headquarters.
Hey, I'm Carrie Whitehead. I am in our Office of General Counsel and I'm Program Counsel for CDBG Disaster Recovery. I am here as a subject matter expert and not providing you legal advice.
Hi, everybody. My name is Michaela Catani, and I'm a CPD specialist in our policy division at HUD headquarters.
All right. So today we're going to learn and understand what duplication of benefits requirements apply to you. We're going to complete a basic DoB calculation, a fairly quick one. We're going to understand how to approach more complicated DoB problems, including how we treat loans before the sunset of the DRA amendments and then after. And then we're going to understand the consequences of a failure to prevent or collect duplicative financial assistance. This is our agenda. I'm going to start with an overview of key concepts, go over the DoB framework, run through an example. Carrie is going to cover the treatment of loans and the sunset of those loan provisions. And then Michaela is going to walk through an example using some really cool new materials. We are really close to being able to post on the website. We're going to give you a sneak peek just for making it all the way to the last session of the clinic. So you guys get to see it before anyone else. And then we're going to go through resources and hopefully take questions. You know, this is your chance to get those, to give us some complicated DoB example or questions, and we're happy to take those. So we're going to kind of briefly go through the sort of DoB 101 because there are a lot of materials on our website right now. We're going to show you at the end of the deck, give you lots of those examples of webinars we have out, the notices to read. There's a lot of good stuff that we've already done on sort of 101 DoB. But essentially, this slide kind of walks you through it. A DoB happens when a person, but when we say person, we really mean an individual, a household, a business, a local government, a state government, or other entity receives financial assistance from multiple sources. And that assistance is for the same purpose, and it exceeds the total need of that assistance. Here's the sources for the DoB requirements. The main one to know is the Stafford Act. You're going to hear that a lot. When it comes to DoB, if you're reading the notices, you'll see that referenced all the time. We also have our Appropriations Act, the basic cost principles, and then they're also referenced in your grant agreements and should be also in your subrecipient agreements. So order of assistance, it's not the same as DoB, but they are related concepts. The main thing to take away here is CDBG-DR always comes last. Not in popularity. I mean, we love CDBG-DR, but in terms of the use of the funds, you want to always make sure you're never paying for something FEMA could pay for or has funds available for, or the Army Corps. Okay, so let's talk about the basic steps to do a DoB calculation, and then we're going to hit an example and do the math. Essentially, your first step is always to assess what your applicant's need is, and this is at a point in time you will assess that need. You're then going to identify what are all the sources of assistance you have received. Did you get money from FEMA? Did you get a loan from SBA? Did you get money from a charitable organization? Did you get a loan from another source? Did you get insurance? Hopefully. You want to make sure you've identified all the total assistance that person or entity received. And then you're going to go to the next step and get to exclude that assistance that is non-duplicative. And that's always the interesting part. You're really going to see in Michaela's example, when she's using our new worksheets, how that process works and how you're going to get to exclude assistance. Because I think that's really a key, because sometimes we count assistance as duplicative when we could have excluded it, which hurts our homeowners ultimately, right? So we want to be really careful when we're going through those exclusions. And then after you've excluded what's not a DOB, you can do the math and identify what is the DOB and calculate your total award. And then if you have an award cap, you want to put in your award cap, and that'll be the cap for the award. And then we do want to note that you can, and we expect you to reassess unmet need when necessary. And that could be when perhaps you run a homeowner rehab program and that homeowner has been a victim of fraud from a contractor. You will need to reassess the need at that time. Maybe they get hit by a subsequent disaster. There are many things that could happen that would cause you to reassess unmet need. So don't forget about that step. All right, a basic example. We're going to talk about Mr. Luckless, and we, as a CDBG-DR grantee, we're going to rehab his business. He owns an electronics business, and that building where his business is located was damaged by a tornado. The estimated cost to rehabilitate his building is $150,000. Mr. Luckless has received $85,000 in total assistance, $65,000 from insurance, and then $20,000 from a local economic development authority. And most importantly, the purpose of those funds from the local economic development authority was that $10,000 of that money was to be used for rehab, and $10,000 was for assistance to operate at a different location while his business is being rehabbed. So let's do the math. So we start with the total need, which we said was $150,000. We identified total assistance, which we said was $85,000. So this is that really important step I was talking about. We get to exclude assistance that we've determined is non-duplicative. And in this instance, it's $10,000 because we're giving Mr. Luckless money to rehab his business, the building in which his business is located. And when he got money from the local economic development authority, only half of that was for rehab. So we want to focus on what were the funds for the same purpose. And so $10,000 was assistance to operate in a different building during the rehab. Those are funds for a different purpose, so we can exclude that from our DOB calculation. So our DOB is now $75,000. That means we subtract $150 from $75, and he can now get up to $75,000. But we have a program cap in our economic development program where we're only giving businesses up to $50,000 for a rehab award. So in this case, we're going to cap that at $50,000, and that's how much Mr. Luckless receives. So infrastructure, we wanted to do a quick walk through an infrastructure example. We had, I think all of us got some questions on infrastructure on the DOB section. So I know this is one where folks want more information. So that's always good for us to take away. But here's an example we can kind of walk through at a very high level. A grantee's capital improvement plan includes the redesign and upgrades for a park that has an outdated playground and inadequate lighting. The upgrades in the capital improvement plan were planned for 2024. But in 2022, a flood inundates the park and causes significant deterioration of that park. So If you're in this position where you had a project in your capital improvement plan and now a disaster hits, what you can do is you can reevaluate your needs. The first step is to think about whether or not you had local funds previously designated, in this case for the park. Are those funds still available? If it was in your capital improvement plan, do you still have those funds and do you still want to use those funds for that project? And are they still in there? Or do you need those funds for another use now that you've been hit by this disaster? And if that's the case, you need to document that and then modify your capital improvement plan if it's warranted. And this is actually not a DoB calculation. It's kind of some steps as an example to use for you to take back, to think about this before you move to your DoB analysis. First, you want to identify your planned pre-disaster needs. You were going to fix that park. You had $2 million in your capital improvement plan to do that. But post-disaster, reevaluating those needs and everything that happened to that park, you now have $10 million in need to improve that park and fix the problems that came with the storm or the flooding. So the next step would be to identify, are there any other amounts that you have available? So originally you had slated $2 million for that CIP that you planned for in 2024. Let's say you also have FEMA funds coming that you could use for this project. So that's around $5 million. You want to make sure the first step always for any unmet needs DR project is to make sure that that activity has tieback and you're able to document that the storm did affect the park. And then you want to make sure your impact and unmet needs assessment and your action plan reflects those disaster related needs and the sources you have available to you. And then in this case, does your unmet needs exceed your sources available? So you've got 10 million in unmet needs, we know, and you've identified potentially, possibly $5 million that are available. So you do have more unmet needs than you have sources available. So that means the project is eligible. And then you can confirm what the next step would really be. Do you actually have that $2 million that you slated, who knows how many years ago, for that park? And that's when you need to, if you don't have those funds available anymore because, you know, post-disaster needs, you need to use them for something more pressing, or they're just not available because you weren't planning on it until 2024. You need to be able to document that, show an amended CIP, and then you can move forward with a project and do your regular DoB analysis. All right, so here's our new worksheet. I'm sure you can see that very clearly. So we developed these new worksheets. Luckily you have the author right here, Michaela. She's the one who built these. She did an amazing job. I'm very excited about these. But the big thing that I want to stress is that we want to issue these to make it easier for everyone across the board to do their DoB analysis. Both from when HUD comes to monitor and then also when the HUD OIG comes to audit. We want to take the guessing out of it, right? We want to use the terms in the 2019 DoB notice, or if you're a 22 grantee, you'll have the DoB sections in your allocation announcement notice and the consolidated notice. We want to make sure we're lining up with the words and phrases in the notice. One thing we see, if you have, you know, one of the takeaways from this presentation is that one thing we often see is grantees will sometimes use terms that they all understand, but no one outside of their agency is going to understand, right? Because they're not terms that we use in the Federal Register notice for 2019 DoB. And that's really what you all should be using to develop your framework, to do the math, to set up the steps. And we've kind of taken away that guessing work by giving you the work, by posting these worksheets. So that's really the key for these. Often what we see is folks using terms, and sometimes it's terms because and this is the pro tip on the slide, if you're working with contractors, often they already have systems built, right? And that's a big selling point for procuring a contractor, is if they've already have this DoB system built that you can use. The problem is that sometimes those were built prior to our 2019 notice, or they just haven't updated it to use the latest terminology we use in that notice. And it just creates confusion. It creates confusion for the HUD reviewer. It creates confusion, like I said, for our OIG partners when they're coming to look, and we're not seeing the explanations we need to see. We're not seeing the terminology we need to see. So hopefully using these worksheets, if you don't use them in your files, at least it'll be a reference point, and you can think about how to adapt your record keeping with some of the terminology. All right, I'm going to turn it over to Carrie.
You guys should all get prizes. And if we had no ethics rules, I would start throwing out free things to you for staying late for math. Thank you. I am just going to do a quick review on loans and where we are now, where we're going. We have to start with terminology. So private loans, never a duplication of benefits. What is a private loan? Standard loans that do not have subsidized interest. The borrower has to repay the full amount of the loan, and you're talking commercial lender terms. Loan is not forgivable, no low interest rate, market rate interest, never a DOB. Subsidized loans might be a DOB if an exception doesn't apply. And so, subsidized loans are just anything that are not private loans. Here are the two terms that were introduced more thoroughly in the 2019 DoB notice: declined loans and canceled loans. While that notice gave a little bit more detail, these terms have been around. We just gave a little bit more structure in that 2019 notice for how to deal with them. Declined loans means there was never a loan agreement, and a loan may have been offered, but it was never accepted. So there were never two parties that signed an agreement. The homeowner, applicant, business could not have drawn from that loan ever because there was never an agreement. Those are never a DOB. However, sometimes you may have a data feed, say from SBA, that indicates someone has a loan and isn't clear about whether that loan was declined or just offered, accepted, right? And so if you don't know, you can't tell, but you can see that they have potentially received a loan, you need to have some sort of documentation to show that the loan was declined. And you can do that with a simple agreement or other document that you develop for that purpose. A canceled loan is the portion of a loan that was accepted, loan document signed, but is no longer available. So it could be the full amount, it could be a partial amount, but it's the amount that was never dispersed and cannot be dispersed. And the key here is that you really do need to have a means of showing that that loan amount is not available and cannot be drawn. The 2019 DoB notice talks about the ways that you document that, but there are basically safe harbors in that 2019 notice that HUD will accept to show that a portion of a loan or the full loan amount is not available and is canceled. Key with that, if it's an SBA loan, you are required to tell SBA that you have determined that the loan was canceled. See the 2019 DoB notice, or for 22 disasters, your AAN that's coming out. 2018 statutory changes kind of solidified the declined loans policy. And there were also statutory changes that were in Section 1210 of the Disaster Recovery Reform Act. And that act has many provisions, but one temporarily amended the Stafford Act. It only applied to 2016 to 2021 disasters, and it sunsets October 5th, 2023. I'm going to refer to that as the DRA Loan Exception. the second statutory provision on declined loans is not limited to DRA disasters. It applies to a broader class, 2014 through 2017, but it's not limited to that class because it just mirrors HUD's treatment of declined loans. So we'll talk a little bit more about that, but just know, we are not reliant on that statutory language, and it does not sunset. Treatment of declined loans is not changing after October 5th, 2023. Under the 2019 DoB notice, when is a subsidized loan a DoB? Well, it is not a DoB if one of three exceptions applies. One, it's a short-term loan for costs of the grantee or costs of the subrecipient that will be reimbursed with CDBG-DR funds. Two, it's a canceled or a declined loan documented as we just discussed. Or three, the DRA loan exception applies. The DRA loan exception has some prerequisites, right? We'll get to those in just a minute, but there are some provisions that were in the DRA that mention a waiver. You don't need a waiver for this provision. FEMA issued a fact sheet that interpreted this provision. We've included the citation here and you can go read it. But at the end of the day, the key things to remember are it applies automatically during the window between its passage and October 5th, 2023. And it also only applies to 2016 to 2021 disasters. It does not address reimbursement. It has implications for reimbursement, but it does not address reimbursement at all. Subsidized loans raise lots of questions. Can a grantee provide a subsidized loan to homeowners to resolve an existing duplication of benefits? What do we mean by that? Let's say you got some CDBG-DR assistance as a homeowner. You went through the DoB process, but later you got an ICC payment from NFIP, increased cost of compliance payments for NFIP, and it comes in after your CDBG-DR award. And you, as the homeowner, spend that increased cost of compliance instead of paying it back to the CDBG-DR grantee. The CDBG-DR grantee cannot provide a loan to the homeowner to say, okay, we'll let you pay this back to us over a few years. That's not what the subsidized loan provision under the DRA allows. If there's a duplication of benefits and it already exists, you can't fix it with a loan. But let's say you're on the front end. You must, to comply with the Stafford Act, prevent a duplication of benefits. So you're going through your DoB analysis and you notice that there is a gap in that DoB analysis, and you are, because of money that applicant has received from another source, say FEMA money, that they spent on something other than the purpose that it was provided, then the grantee can provide assistance as a subsidized loan without causing a duplication of benefits if the exceptions, the prerequisites under the DRA applies. So those are the final subsidized loan award for the DRA qualified disaster has to come through in loan agreement signed before October 5th, 2023, when the DRA sunsets. And by DRA qualified disaster, we mean a disaster that occurred between January 1st, 2016 and December 31st, 2021. Second, the grantee must determine that all federal assistance, FEMA, SBA, CDBG, DR, any other source of federal assistance is used towards a loss suffered as a result of a major disaster or emergency. It does not have to be the purpose for which it was provided, but it has to be a disaster-related loss. So for example, if it's provided for rehab of a structure, but it was used for a disaster damage, replacement of a disaster damaged car, that is for a disaster-related loss. And so that's, but you must make that determination. And then third, the loan must be a bona fide loan, and we'll get to that. What is a bona fide loan? Well, this is not a defined term, but it has been examined by many different parties for many different purposes. And so HUD has tried to set out some indicators that HUD is going to look to determine whether the assistance in a subsidized loan is a bona fide loan and not just a grant called a loan. So we want loan documents. We want principal and interest schedules. We want to see several other indicia of loans. A good example might be that there's security or collateral required, or that the borrower could reasonably be expected to repay the loan based on their income over the time period of the principal and interest repayment schedule. So if it's a 20-year loan and they're paying back $1,000 a year and that's all they can manage, they could actually repay the loan. And if they don't, it can be reported to a credit agency and it's treated just like any other commercial loan in that regard. But for other reasons and in other situations, forgivable loans can be bona fide loans, and that's true for CDBG-DR as well. It's true for purposes of treatment of loans under NFIP, and we're similarly treating subsidized loans that are forgivable as loans when they have all the indicia of loans for CDBG disaster recovery. What does that mean? Forgiveness is not a foregone conclusion. It has to be dependent on meeting the conditions for the loan. So for example, an economic development loan that's forgivable if a certain number of jobs are created has a condition on it. And it's not a foregone conclusion that the jobs will be created. And so it can be forgiven if the loan terms would be enforceable if those jobs were not created. And the repayment period does not have to be the same period as the forgiveness period. So while a 20-year loan might be necessary so that if it's not forgiven, your applicant can actually repay that loan, it may be reasonable to forgive that loan over a period of 5 years because that is the benefit that your mission in carrying out disaster recovery is tied to. In other words, the benefit to you as the grantee for being able to make that request or impose that condition. What are key requirements for a grantee to consider if you're offering subsidized loans to homeowners? First of all, it has to be in your action plan. And you need to document through your program policies and procedures and the loan documents themselves that this loan is a bona fide loan so that it falls within the DRA exception. If it looks too much like a grant, it's not covered by that exception. It's going to be financial assistance in your DoB analysis, and it's going to create a DoB. And we've provided a couple of resources here that I think are helpful. They'll be linked and available to you in this presentation online. So how can grantees, this comes up a lot, verify that all the federal assistance was used for a disaster-related loss? This is a question in some cases of policies that are reasonable. You know, how far you have to go to prove this is going to be based on, the risk that the money was used for something other than a disaster-related loss. Obviously, you can always look to receipts, bank statements, but you might also, when those are not available, be able to look at inspections or reasonable sources of documentation that might be determined acceptable based on the level of risk that you see that the funds could have been spent for something other than a disaster-related loss. So, a claim for insurance, for car insurance for a flooded car, going back to our earlier example about when FEMA funds were spent for replacement of a disaster damaged car, pictures of the disaster damaged car, something that's going to help you verify, yes, that was a disaster related loss. You can use self-certifications, but consistent with the definition of certification in 24 CFR Part 91, which is the consolidated planning regulation, you need to have some sort of additional backup that is your trust but verify, right? Some sort of verification. How much verification is necessary is, again, going to depend on risk. It's a reasonableness test, but you need to document why you think it's reasonable. And you need to document in the applicant file that if you're trying to use the DRA exception for a DRA qualifying disaster, you've completed this verification before you fail to include loans as part of the financial assistance. So this provision sunsets on October 5th, 2023. And so here is the key takeaway from today. If the grantee makes a final award of that subsidized loan for a DRA qualified disaster before the DRA sunsets on October 5th, 2023, it is okay to continue to treat that subsidized loan as an accepted loan that's covered by the DRA exception for the life of that loan. And that's true whether you're making the loan or SBA is making the loan or your local economic development association is making the loan. Look at when the loan was made to determine whether it's covered by the DRA exception or not. And it needs to be by loan documents signed before that sunset. That's enough. It's okay if progress payments are going to happen after that October 5th sunset. You're just going to look at when the applicant has a legal right to access those loan funds. So what exceptions for subsidized loans could apply after the DRA sunsets? So the short-term loans for costs covered by the grantee or the subrecipient still going to exist. Really key point here, make sure that loan document says it's a short-term loan. Because if your intent is to repay it with your CDBG-DR funds once you get them, but it's a 20-year loan, you can't take advantage of this exception. It will be treated as financial assistance. So make sure your loan term indicates that it's a short-term loan. Canceled loans and declined loans, those provisions are not changing. We're not changing our treatment of those. They will not be treated as financial assistance. Okay, so for 2011 to 2013 disasters, they were never covered by the DRA and they're not covered by the 2019 DoB notice. They had a policy document that was a policy memorandum that really interpreted what was a necessary and reasonable cost for those grants. And grantees had to take certain extra steps to basically show that providing loan assistance after a loan was declined was actually necessary and reasonable. That is limited to those disasters and no longer applies for 2015 disasters and forward. We did not have CDBG-DR in 2014, so I'm not skipping a year. 2015, they are not subject to that 2013 notice. They are covered by the 2019 notice and same treatment of declined and canceled loans. 2016 through 2021, these are your DRA covered disasters. These are the years in which after October 5th, 2023, the grantees are going to be able to take advantage of the DRA loan exception only for those loans that were made before October 5th, 2023. And again, you know, you've got the DRA exception that is available to you. Keep in mind that you do have to notify the lender and have this applicant agreement, the documentation we talked about for the canceled loans. And then it is okay to follow the reimbursement procedures that are in that 29 DoB notice. This is not authorized by the DRA. As I mentioned, it's an implication of the DRA because a subsidized loan under the DRA is not financial assistance, then it is not duplicative to reimburse a homeowner for the costs that are paid with that subsidized loan. You are not paying the loan back. That's not the eligible activity. You are paying for the activity, the underlying activity, whether it's an economic development activity or it's rehab of a homeowner's home or it's infrastructure. If you're paying for that underlying activity. And so that's still allowed subject to the conditions in the notice. Whenever you're doing reimbursement, you have to follow HUD's rules. HUD's rules in this case are really designed to make sure that you all are meeting your 70% overall benefit requirements. So prioritizing assistance to LMI, not going above 120% AMI unless you have a hardship exception, which are really rare. And then you just can't reimburse these costs after October 5th, 2023. So if you need to do reimbursements for costs paid with subsidized loans, just do that before the sunset. And then for 2022 disasters, The DRA currently is not extended beyond October 5th, 2023. And so these disasters are not subject to the 2019 DoB notice. The allocation announcement notice will cover the remaining exceptions that will apply. Obviously the declined and canceled loans and the short-term loans for costs that are paid by the grantee or subrecipient. And now we're going to go through some more concrete examples.
All right. Good afternoon, everybody. Thanks for sticking with us. We are coming to a close. We have some more math ahead, so bear with me. We are starting with a homeowner rehab and reconstruction example because this is something that across the portfolio, almost all of our grantees are doing this. So this example we felt was most applicable in this scenario, and we'll be using the worksheet with this setting in mind. We're going to work on some worksheets geared towards infrastructure and economic revitalization as well. So just keep that in mind too as we go through this. In this example, Charlie is a homeowner and his home was destroyed by a 2020 wildfire. Charlie does all of his due diligence applying for all sources of assistance that are available during his recovery period. Now, CDBG-DR funds become available to his county and he applies for the program to finish rehabbing and reconstructing his home. During the application stage, the CDBG-DR grantee collects all information from the different sources of assistance that Charlie's received so far. So he discloses that he's received money from his insurance company, from FEMA, SBA, as well as a state grant. When the CDBG-DR grantee goes out and does the inspection, they determine his unmet need at this point in time is $300,000. So what's the maximum amount of CDBG-DR funds that Charlie can receive? And to make this determination and come to this conclusion, we need to do a little bit more research and a little bit more analysis. We need more information. Specifically, when we look at all the sources of assistance that Charlie received, we want to pay special attention to the funding that he received related to rehab and reconstruction. And so some of our partner agencies term this as repairs. So those are the most important pieces that we really want to look to when we're thinking about Charlie's DoB analysis, because we want to see if we can exclude anything. So Jen and Carrie both kind of went over the different exclusions, and there's two main exclusions in a DoB analysis. Whenever you receive funds for a different purpose than the CDBG-DR funds, or the same purpose but are used for a different allowable use. And so that's something we're going to factor in to Charlie's analysis. When we ask for documentation from Charlie, he can show us that he used $50,000 of his insurance money to repair the foundation and $12,000 of his FEMA funds to repair the exterior and set up the structure. However, he spent $8,000 of his FEMA funds purchasing a car. And for this example, the car was not damaged by the disaster. He just needed a new car, so he used that funding to buy a new car. He also tells us that he still has $5,000 of FEMA funds in his bank account that he has not spent yet. Continuing on all of the sources of assistance that Charlie's received, he can demonstrate that he also used all of his SBA funds to repair the exterior of the home. So keeping that in mind and thinking about the DoB framework, does Charlie have a DoB? What additional information do we need? And what documents do we need to include in Charlie's file to help follow along with the DoB framework? So keep that in mind as we walk through the worksheet. So these screenshots, I know they're probably a little bit small for you all to see, but in general, it's going to follow all of the steps listed in the DoB framework. So we're going to start with step 1, which again is assessing the applicant's needs. So we know from our inspection when the CDBG-DR grantee sent the inspector out that Charlie's unmet need is $300,000. Now we're entering step 2, where we're identifying all the different types of total assistance available to Charlie. So in the worksheet, you're going to select yes for any of the categories of assistance that your applicant received. You're going to include how much funding was provided, and you're also going to list the purpose of the assistance. And again, it's so important to see if your beneficiaries are spending their funding for the intended purpose that they were provided. So this worksheet just goes down the list, identifying all those different sources. So we have the FEMA funds listed, the subsidized loans. And here I'm just going to pause because this is a DRA covered disaster. We said it was a 2020 disaster. And so some of you may be wondering, why is this included at the total assistance stage? It's because we know that Charlie received this funding, and we need to do a little bit more analysis to determine if the SBA loan should be counted as assistance or not. So we're going to circle back to the SBA loan. And then finally, it asks about additional assistance. And we know that he also received a grant for general disaster recovery purposes from the state. So here in total, this final line on the screenshot here shows that Charlie received $255,000 for his recovery. So now we get into the fun part, the exclusions, which is step 3. Now what we have to do is walk through each of these sources of assistance to determine if there's any remaining assistance that Charlie has in his bank account, and if Charlie was using his assistance for the intended purposes. And so we know right off the bat that Charlie still has $5,000 in those FEMA funding for repairs. So he still has access to that funding and has documentation that he has not spent it. Next, we look to the following sub-question that gets into that intended purposes. And we know that he has documentation for everything except for the $8,000 that he used to purchase a new car. And so that's important. And we'll circle back to these numbers. So continuing on, now we get into the 2 main exclusions that are described in that 2019 DoB notice, which will also be in the allocation announcement notice portion for our new grantees. So the first question is, was assistance provided for a different purpose than the CDBG-DR funds? So in this example, the CDBG-DR funds are being used for rehab and reconstruction. So anything that was provided to Charlie for a different purpose, and he shows that he spent it for its intended use, he's good. He's going to meet this exclusion. And so we know that he received $100,000 for loss of contents and debris removal for insurance. Check, that's a different purpose than rehab. He also received $25,000 from FEMA for temporary housing assistance. Again, a different purpose than the CDBG-DR funds. And then finally, this is one of the ones that we point out through guidance in the 2019 DoB notice, is that funds for general, non-specific disaster recovery purpose can also be counted as a different purpose than CDBG-DR. And so that's what he received from a state grant. So again, he's clear there. So in total, when we count up all of those different sources of assistance, we reach $150,000 that we can exclude from Charlie's DoB analysis because it meets an exclusion funds for a different purpose. The next step is to look at funds provided for the same purpose, so rehab, as the CDBG-DR funds, but used for a different allowable use. And we know that Charlie has spent $50,000 from insurance and $12,000 from FEMA to do his repairs and his rehab and his reconstruction. He can document all of those costs. So we can show that he meets this exclusion with a total of $62,000 that can be excluded for the same purpose as the CDBG-DR funds, again, rehab, but used for a different allowable use because your CDBG-DR funds are going to build off of what he's already done. So there's those 2 totals there for you. Yay. And then finally, we circle back to that SBA loan. So because this is a DRA covered disaster, we're going to ask a few more questions. First, we're going to see if the loan meets the declined or canceled loan provision that Carrie just talked about, which would be an exception to the DoB analysis. And in this case, Charlie actually used the loan and he can document that he used it for disaster-related purposes of rehabbing his home, setting the structure, getting it ready. And because it meets all of those exception criteria, we can determine that in this case, the SBA loan should not be counted as assistance. And it's again because it met all of the criteria covered by the DRA loan exception. With that in mind, we come and we reach a total of $242,000 that can be excluded from Charlie's DoB analysis. And so again, that's the $150,000 that was provided for a different purpose. The $62,000 that was the same purpose, but used for a different allowable use. And then the $30,000 SBA loan is no longer counted as assistance because it meets the DRA loan exception. With all of that information in mind, we finally reach step 4 to identify the total DoB. So we go back to step 2 and list the total assistance that Charlie received. And then we subtract the non-duplicative funds that we just determined. So we have $255,000 minus $242,000, and we reach a total DoB of $13,000. And so logically, when we reach this number, it makes sense, right? Because Charlie spent $8,000 buying a new car and he has $5,000 of unused funds from FEMA. So continuing on to step 5, we calculate Charlie's total CDBG-DR award. And his total CDBG-DR award is the total need, so $300,000. We subtract his DoB, which is the $13,000, to reach a maximum CDBG-DR award of $287,000. So that's his maximum CDBG-DR award. Thinking this through some more, we know that Charlie still has the $5,000 to contribute towards this recovery. So after all of this math, we know that Charlie still has a gap of $8,000, and that's the $8,000 that he spent purchasing the car. And this is a real life scenario that all of you are faced with every day when you're running your applications. So what can you do? One solution could be reducing the scope of work for Charlie in a way that you can still reach the certification of occupancy and get Charlie in the home, maybe without the full scope that you originally planned for Charlie. So if you can do some scope reduction and still get to that occupancy standard to meet a national objective, you're in the clear and Charlie can be served. So let's circle back to why the $50,000 from insurance and the $12,000 that Charlie used for rehab, why that isn't a DoB. And so I put this citation just on the screen for all of you. This is coming from the 2019 DoB notice. And it just lays out in plain language why this is not a DoB. And again, it's because it's for the same purpose, rehab, which is the eligible activity, but you can document that it's used for a different allowable use, which is a different cost than how you'll be spending the CDBG-DR assistance. And I think this is a step that some of you may be missing when you're doing your calculations. So just make sure that you keep this in mind and you refer back to it when you're writing your policies and procedures and you're doing your analysis. So what if Charlie hasn't spent his insurance money or his FEMA assistance yet in our example? How does that change his DoB analysis? It changes the DoB analysis because Charlie would have all of the funding available to him. And so he would have $75,000 of unused funds. And so it would be a gap of $75 that he can then contribute towards his recovery. And then finally, how does this change for a 2022 disaster? So if Charlie's wildfire was a 2022 disaster, which is not a DRA covered disaster, this changes because now the subsidized loan is treated as financial assistance. So you would treat it as any other form of assistance. And if it meets one of the exclusions, funds provided for a different purpose or funds provided for the same purpose, but a different allowable use, it wouldn't be a DoB.
Can I jump in? I think that's one of the things, even with the three of us working on this presentation and talking it through. I think with this loan exception, a lot of us thought, well, it's just as a shorthand with the loan exception, a subsidized loan is not a DOB. So when you take away the exception, a subsidized loan is a DOB. But really, it's that subsidized loan just becomes another source of assistance, and you're going to treat it the same way you would treat the FEMA funds or the other funds that are part of that DOB analysis. So it's really just about how you treat it. And so it's not that it's 100% a DOB, it's that it depends, right? Because it's then going to be part of it's then considered assistance. It's going to be part of your DOB analysis. For the folks that have those grants that are, in the 19, 20, 21 that are going to sort of have some DOB analysis before the sunset and then have some DOB analysis where folks might get loans after that period. You just want to think about that in your policies and procedures. It's not that it automatically becomes a DOB when that goes away. It's just going to be part of your analysis.
Thanks, Jen. Okay, so that brings us to some of the key takeaways from the session. And here we just want to reiterate that it's really critical to understand how the DOB framework works, especially those exceptions and the exclusions to help your beneficiaries. We also just want to emphasize to please use terminology in the notice, make everyone's lives easier so that we can all reach the same answer when looking at all of your DOB analysis and doing file reviews. And then additionally, for those DRA qualified grants, we want you all to be prepared for the sunset and ask questions. Let us know what questions you have. How can we help you prepare? We have an FAQ coming out that speaks to this a little bit more, and so that should be out really soon. We'll do an announcement through the HUD Exchange, and all of your grant managers can send you the guidance. It'll be on HUD.gov, and that should be able to assist you as well as you're doing these DOB analysis and working mid-implementation, both before and right after the sunset. So we just want everyone to be prepared, ask your questions. We know it's complicated. We know it's confusing. So in addition to that, here are a list of some resources for you all to consider. We have the Tools and Templates Library. We have previous recorded webinars. We also have a policy bulletin that goes over the 2019 DOB notice. And then again, those FAQs and the worksheets will be coming soon. And with that, we have reached our Q&A session. What brave soul has a question?
We've stunned you. You have no questions.
I can just say all the information we provided here on that DOB sunset and that you need to have your loan agreements should be signed before that sunset. That's all going to be part of those DOB FAQs that we'll post. So you'll have sort of a HUD official document that has those questions and answers spelled out, and we'll put that on the HUD website probably first, and then you'll see the worksheets after that. We want to just tweak them a little bit. Going through this has helped us. If you look at these slides and you're like, I don't understand why you're asking this question, or if you have feedback on the screenshots that we provided, let us know. Feel free to reach out to your grant manager, and if you guys have any feedback on those too, because we really I'm very excited about the worksheets. I really hope that everyone's going to be able to use those, and it'll give us all, it's sort of a dictionary for all of us, so that we all come to the table using the same terms. And that means our partners in, the OIG as well. And we're all sort of on the same page on how we're doing that math.
I want to just highlight some of the questions that came up in my one-on-one sessions that were really about the two exclusions. I'm really glad Michaela put in a slide on same purpose, different allowable cost, but same purpose versus different purpose also is complicated, right? And it's not always really clear. So, your grant manager is 100% available to kind of help you work through that. And it's one of the things that we've seen the OIG make audit findings about in the past. And sometimes we agree with them, sometimes we don't. It's always a good idea to check on the front end before audit time comes. And so I would just encourage you to sort of take a look at what, you know, if something's on the line as to whether it's same purpose or different purpose, then we can talk about it. And a good example might be, within an insurance payment, which is largely for structure. Some of it might be for structure that you're not covering. It's not eligible under your program. So, the first starting point would be, what are the things, the costs, the specific costs that are eligible under my particular program that I'm running? If that applicant couldn't get money for it from you and they got money for it from someone else, it's possibly a different purpose. And I think that's, ground truthing that on the front end when you're developing your policies and procedures is a great way to avoid an audit. And, when you all deal with your policies and procedures pre-grant award so that you can support HUD certification and your own certification, you're going to have a very general level of policies and procedures that are just necessary to get going. But as you move on down the road, those policies and procedures are going to evolve as you start to answer questions that are unknowns. You don't know what questions you're going to have further down the road or after you get, 5,000 applicants to your particular program. And so as you need to modify your policies and procedures, that's another place where your grant manager can be really helpful in connecting you to a subject matter expert on this topic. And I think audit finding avoidance is something that we all appreciate and, we want to work with you on.
Well, that takes us into our concluding remarks. So I personally just want to thank everyone for being here. It was so great meeting you all, listening to some of the innovative ideas that you're taking on and some of the challenges you're experiencing in your region. So it's really great learning from you, and I hope you all learned a lot. With that, I will turn it over to Jen Carpenter.
So just in closing, on behalf of Tennille had to leave after day one because of some last minute obligations. I know she would want to take a minute to thank everyone who made the event possible. So first and foremost, we have to thank our folks on the HUD side. Our lead for the clinic this year, Olivia Healy, did an amazing job. Her clinic, our HUD clinic team, Michelle, Christy, Celeste, Michaela, Bryce, and Kyle, thank you guys all for helping. The rest of our policy division for helping with content reviews, our folks in operations who are working with our partners in the field this week, and then our folks in grants management division who really stepped up to do one-on-ones and trainings this week. And then of course our lead TA provider, ICF. Thank you so much, Calvin and Aliska and Chantal, for all your work on everything leading up to this event. Thank you to our partners at Cloudburst, Marissa, and partners at Civics. It was a huge undertaking to finally do this event in person and then also add this virtual component. We really hope it was a great experience for all of you and that we'll keep doing this event. If you have suggestions, feedback, tips, especially for those who were joining virtually, if you hear from them, we'd love to hear how that experience was for the folks who couldn't be here in person. But we're so happy to see everyone. I really hope that everyone is walking away with, most importantly, their questions answered, that you were actually able to solve some problems. That's why we're here. And I hope you all felt like you were able to do that this week. And it was great meeting everyone. And yeah, we'll just continue doing this and hope to see everyone next year. Thank you.